Many of you already know me. I'm Sharon Flesher, Executive Director of IFAR, the International Foundation for Art Research, and on behalf of everyone at IFAR, our board, several of whom are here tonight, our council members, our staff, and our volunteers, I'd like to welcome you to another what I know will be a wonderful program in our long-standing series of IFAR evenings. And I also want to thank you for coming. If this is your very first IFAR evening, and I know it is for many of you, you've really been missing out on a lot. We've been hosting these programs for more than 30 years. So I invite you to pick up some of the literature that we have about us outside in that area in which you registered and where we're going to have a reception after the program. And that way you can learn a little bit more about us, and who knows, maybe it'll spur you to subscribe to our award-winning journal. And by the way, the new issue, which is on display outside and is just being mailed to our subscribers, is just out. Even better for us, even more than being a subscriber, maybe you'll even choose to become an IFAR supporter, because as I never tire of saying, we could certainly use that support despite our rather grandiose sounding name, International Foundation for Art Research. We are not an endowed foundation. We are rather a nonprofit educational and research organization, and we do so much for the public and the art world, an awful lot of which is behind the scenes. And the issues we deal with are increasingly in the news these days, making our role far more important than it ever was. And also then you'll be the first to hear about our programs and even come for free. That's a nice incentive. Our last program in October was devoted to the Detroit bankruptcy situation and its potentially disastrous impact on the Detroit Institute of Arts. Very exceptionally, we videotaped that program, and we've now gotten the videotape back, and it's going to be posted on our website in the next few days. We're going to try to do the same for this program. I'm not promising, however. While you're on our site, ifar.org, do check out our web-based educational resources. They include our provenance guide, which we're updating and expanding now, our catalog Resale database, and our very ambitious art law and cultural property database. Now, for tonight's program, which I'm very proud to be hosting, devoted to resale rights for visual artists in the U.S. Resale rights, as many of you know, are better known or also known under the term droit de suite, and they're not a new idea. As you'll hear from our speakers, it goes back almost a century in France and now exists in many countries around the world, including the European Union. But to say the least, the concept has not really caught on in the United States, and the one state that did adopt it, California, recently had its 1976 law struck down as unconstitutional. That ruling is on appeal, and I know you're going to be hearing something about that too later this evening. IFAR organized this program because of a confluence of circumstances and events, really. One, I just mentioned the California case, which is actually, by the way, more than one case. It's two cases that were consolidated by the court, one against Christie's and the other against Sotheby's. That case is on appeal to the Ninth Circuit. Secondly, a review by the United States Copyright Office of the implications of enacting a federal resale royalty law is also underway. And when I began planning this program, the Copyright Office's recommendations or report was expected out before now, certainly by now, and I timed the program in part to come soon after what I thought would be the release of that report. I didn't count on a little hitch called the government shutdown. Nonetheless, our distinguished speaker, Karyn Claggett, from the Copyright Office, the Associate Register of Copyrights, will fill us in on what happened during this year-long research study project and what was involved in it, the timetable for its release, and maybe, although I don't think so, some of what's going to be in that report. And third, and perhaps the most significant reason in these confluence of events, was that a bill was introduced into the last Congress by Congressman Jerrold Nadler of New York, advocating artists' resale royalties. That bill, H.R. 3688, was not enacted by the Judiciary Committee, or failed. The Judiciary Committee failed to act on it in the 112th Congress, which ended last January. And a new version of the bill is expected out soon, or expected to be reintroduced by Congressman Nadler soon. So we're very honored to have the Congressman here with us this evening to tell him what he can about this new bill. We have, as you see, 5 very distinguished speakers to address what clearly is a very timely, important, and frankly often divisive subject of artist resale rights in the U.S., because it really does exist elsewhere already. In addition to Karyn, Claggett, and Congressman Nadler, whom I've just mentioned, our other speakers include Philippa Loengard of Columbia Law School, the Kernochan Center at Columbia Law School, Theodore, the founder and president of the Artists' Rights Society, and Sandra, Cobden, general counsel at Christie's. I'll introduce them in turn in a little bit more detail as they speak. The speakers will be speaking in the sequence in which you see them on the stage, starting with Philippa Loengard. They've been chosen not only because of their distinguished accomplishments, but to represent some of the constituencies affected by an artist's resale rights bill or enactment. Obviously, in a program of this length, we can't have every constituent group that might be affected. I know that there's no artist, and I know that there's no one officially representing the museum community and whatever. Some of the speakers will have to speak for these groups, and I know we have many people in the audience who also represent some of these groups. After the talks, which will go between 5 and 10 minutes each, so they're not really lengthy talks, we'll open the program to discussion amongst the panelists and to the audience. Everyone who comes to IFAR programs knows how much we like Q&A at IFAR. So we really do welcome your questions. We have an equally distinguished audience as panel. And then after that, we'll ask you to join us for the reception outside. So with no further delay, I want to introduce our first speaker, Philippa Loengard, whom I know and most people know as Pippa, who is the assistant director and also lecturer in law at the Kernochan Center of Columbia Law School. And as an academic, Pippa's role is to provide a little bit more of an overview than I've just provided and offer some minimal data on this subject. And it's interesting about data, and you'll probably hear about this evening, is how much the data is used on both sides, depending on how one wants to use it and extract from it. And perhaps also raise some concern. So I introduce Pippa. Do you prefer that I call you Pippa now or Philippa? Okay, Pippa, okay.
That goes for you too. I'm not sure this is the most effective microphone ever. So I'm going to talk really loudly. The bonus of being a lecturer. Can everyone hear me? Okay. First of all, I want to thank Sharon for putting together this wonderful panel and discussion, and for all of you for coming. And as someone who puts together these discussions on a fairly regular basis up at the law school, I want to thank Sharon's staff, who I know worked super hard to get everything organized. So thank you so much. This is a very timely issue, and it is a very controversial issue. So it'll be an interesting discussion we have today. I am going to start off by not taking a partisan view and just the facts, ma'am, background, so that we all know where we're starting from. Many of you in the audience know more than I do, and some of you may not know as much as your neighbor. So I'm going to start at the very beginning, so to speak, and I may bore some of you, but if you hold on for 7 minutes or so, the discussion will get more partisan as we go. The resale royalty is really a compensation to the creator of a visual work after the initial sale of said work. So compensation for secondary market sales. It's been called a tax, a tariff, a duty, compared to royalties received by authors of books that sold and actors for reruns on television or showings of films in secondary markets. In countries with the regime, the royalty is sometimes paid to artists for every subsequent sale. In some countries, for only the second sale after the initial sale. It originated in France in the 1920s, the image of the starving artist who had created works that had gone on to great fame, notoriety, and value, and on which he was not profiting, and he was living in the slums with his poor family while his works gained all the fortune that should have been his. And that reputation and the idea of the resale royalty is something that helps the starving artist, helps the person who has created and not received proper remuneration. Hello? Continues to this day. So since the 20s, about 50 countries, including, as Sharon said, many in the European Union and Latin American countries, Australia, to name a few, have adopted the provision. Notably, the United States and China, the two largest art markets in the world, have not. Both have recently entertained proposals. We are not alone. China toyed with the idea as well in the past few years, and there's been controversy around both. For now, China, I have heard, has put it on the back burner, and the Chinese and Hong Kong markets heat up. Currently, the United States is the #1 market, and China has gained much ground and is now the second largest market in the world. So the EU introduced the resale royalty across all of its countries through a directive in 2006. The term is life of the author plus 70 years, the same copyright term that we have. I'm going to describe the law very briefly and basically. It has a cap of 12,500 euros. That's the most that a seller must pay back to the artist and the artist collecting societies. It's regressive, so the first amount of value in a work is taxed at a higher rate than the more expensive work. So a work, say, up to 50 euros is taxed at around 4 or 5%, while a work generating over 500,000 euros of profit is taxed at a very small rate of a quarter, 0.25%, and that's on the profits made. It cannot be waived or transferred. It does not travel with the copyright owner. It remains with the artist. And the artist must be either an EU national or from a country with reciprocal rights. So that would not apply to American artists at this point who sell abroad in foreign markets. In the UK, the second largest market, and everyone sort of was looking to see how the UK would do because there's such a prominent force on the art market. In the UK, it applies to pieces sold for more than 3,000 euros, and again has the same regressive rates as the directive mandated. And the question everyone has sort of been watching is, how does it affect sale? And the data, and I'm going to be the first of many to talk about data, and you can interpret data as you wish, and data, as you know, can be interpreted in many different ways by different people. But there has been a dip in the European market and the British market since the introduction of the resale royalty. But of course, it's impossible to isolate the reasons. There's so many reasons why art sells. And so I'm not going to go out and discuss the minutiae of this. I think people later on in the panel are going to do that. In Australia, which instituted the resale royalty in 2010, and because it's not part of the EU directive, obviously has different grounding rules. It's a 5% flat royalty payable to artists only on the second transfer of ownership, and only if over 1,000 Australian dollars. So it goes to the artist again, not the copyright holder. Again, it has the same copyright term, And there is a federal collecting society, as there are in different countries throughout the European Union. And all art market collectors and sellers must report sales to that collecting society. So those are sort of the largest countries that have the resale royalty right. Places like Uruguay and the Philippines have it too, but as you can imagine, their art markets are generally smaller and less forceful in the general market, so I'm not going to go into those details. One thing of note in smaller countries is that their resale royalty is not consistently applied. And that was a problem in California, which ended up bringing the suit against the auction houses, Sotheby's and Christie's. To recap, in California, the law was that if there was a 5% resale royalty, if the sale was more than $1,000, and it was paid if the seller resided in California or the sale took place in California by an auction house or dealer. There was no royalty paid if the seller sold at a loss. And so what the auction houses tended to do was take their large contemporary art sales out of the state and sell them in New York to avoid being caught under the statute. It was struck down as unconstitutional under the Commerce Clause. For those of you who didn't go to law school, shame on you. No, I'm just saying. Because it directly affects commerce occurring wholly outside of a state, and that's the purview of the federal government. Interestingly, the artists who brought the suit, which included Chuck Close, Robert Graham's estate, Laddie John Dill, have not yet involved themselves in the federal resale royalty debate, and it'll be interesting to see where their appeal goes, and if it is upheld that it's unconstitutional, whether that they become more vested in a national federal resale royalty. Right. I'm briefly now going to touch on Congressman Nadler's proposal, the Equity for Visual Artists Act, often called the EVAA, and so if people around here are speaking of it in shorthand. It applies only to works sold at auction that are over $10,000. It's flat 7% of the retail price, no cap on the amount sold, amount that the seller would have to pay back. That 7% would go to a collecting society. Those would be established, and the criteria for those being established are in the proposed bill, which I'm sure you've read. And basically, after administrative costs, the money would be split between museums and the copyright, the artist or copyright owner. I think that Congressman Nadler and Mr. Theodore are going to talk a little bit about a revamped bill, and so I'm not going to go into the museum part that much. I think that's going to sum up my background, because I think you're all very well versed in it. And I'm going to turn it over to Congressman Nadler to talk about where we are now and what his thoughts and motivations are.
Well, thank you very much. Motivations are obvious. Most creators, such as author and playwrights, see the real monetary benefit of their intellectual property through the power of copyright protections to control their work's reproduction and public performance. Visual artists, however, are primarily compensated based on the first sale of their work. Therefore, visual artists lose out on any increase in value of their creation in the future, an increase in value that could be significant, with the benefit going to those who buy and sell their art, and they're getting no benefit from it. Other jurisdictions, other countries, such as the European Union, have recognized this inequity and provide visual artists with a royalty on all future sales of their works. I introduced H.R. 3688, the Equity for Visual Artists Act, in the last Congress, 112th Congress, to implement a resale royalty right in the U.S., because I thought it was fair. Senator Herb Kohl of Wisconsin introduced the Senate version of the bill. In our bill, the royalty would be paid on certain public sales at large auction houses. Since we introduced the bill, there's been a lot of support for the idea from visual artists and those who represent them. There's also been a lot of criticism, primarily from two large auction houses, namely Sotheby's and Christie's. What a surprise. We asked the U.S. Copyright Office to study the issue and to report back with recommendations, and indeed the Copyright Office has been helpful in bringing stakeholders together and airing concerns. But we have not seen their report. It's reportedly going to come out shortly, but we haven't been able to wait for it, so we're proceeding without it because the 113th Congress is almost half over. It will be half over in 2 weeks. We appreciate both criticism and praise, and we're now prepared to respond with a new draft of the legislation, which was completed, at least the draft was, earlier today. As you know, Senator Cole retired and can no longer be our Senate sponsor. I'm pleased to announce we have 2 new Senate sponsors on board, ready to introduce the bill in the Senate this session. Senators Tammy Baldwin of Wisconsin and Senator Ed Markey of Massachusetts, who is, I think at this moment, the newest, or the second newest senator after Cory Booker, and who holds the record, has nothing to do with this, but I have to mention it. He holds the record of all senators in history who previously served in the House as serving longest in the House before their election to the Senate. He's been in the House since 1976 and was elected to the Senate a few months ago to succeed, well, he was elected last year, succeeded Scott Brown. I'm sorry, succeeded, no, he didn't, yeah, he succeeded Senator Kerry, who was appointed Secretary of State. They will bring, hopefully, a new energy to the bill and make for great champions in the Senate, and they're both good, very good legislators. So what does the new bill look like? Some have said that setting the royalty rate at 7% was too high. Europe has a lower percentage, and perhaps we could lower the royalty rate. We have listened, and our new bill will reduce the royalty rate below 7%. The exact amount is not determined yet, but I suspect it will be in the range of 5%, but we'll see. Some had criticized the provision in the bill that takes 3.5% of the fee and dedicates it to a fund for museums. So 3.5 of the 7, half would go to a fund for museums to purchase the work of living artists. We heard from some museums who said they didn't want that money. Well, we've listened, and our new bill will completely eliminate the section dealing with museums, which means that 3.5% will go to the artists, not to the museums. Others had criticized the bill for only applying to sales above $10,000. They felt it didn't reach enough artists and would only benefit the very wealthiest artists and their families. We felt there was some justification to that, so we'll lower the limit on sales in the draft bill to $5,000, cut it in half. Despite hearing the concerns of some, we've decided to keep several other provisions and limitations in place. Some had thought we should extend the royalty collection process to galleries. For a number of reasons, we have decided, at least for the moment, not to do so. We believe public auctions offer the most transparency and make the most sense as a place to start when collecting visual artist royalty fees. It also, in terms of passing the bill, eliminates an entirely new source of opposition, namely all the galleries. We will consider lowering the threshold of business a public auction house must do, currently set at $25 million, to include more public auction houses. We've not yet set a threshold level, but discussions are getting close. In conclusion, we're making progress toward the final touches on the new bill. As I said, we have a draft as of today. I can't go into the details of exactly what's in the draft. It's still got to be discussed with the Senate sponsors, and but it'll be public probably in January. And we're moving forward with new energy in the House and Senate. The purpose of this effort and its motivation is the issue of equities for visual artists. Why shouldn't the artists, the creators, benefit from the sale of their works? Can we design a system to fairly compensate them for the growing value of their works? And you all know the question of growing value. I think we can and should. Because of reciprocity, if we did this, the U.S. artists will benefit from Europe's artist compensation system, and we can help harmonize our two systems to the extent possible. Rather than a race to the bottom where visual artists lose, we should be working to lift up all artists by including a royalty rate here as well as in Europe. And we must be careful that our rate does not undercut sales here in the United States, so our rate will not be higher than it is in Europe. There's one more benefit to increasing artist compensation through a royalty system. We may be able to encourage living artists and help them build up their collecting societies. In doing so, these societies will be able to help the individual artists band together to support their common interests. Artists, like professional athletes, musicians, or actors, all do better in securing their rights and proper payments when they band together in collective groups. Imagine where songwriters, and for that matter, singers, would be if they didn't have collection societies to deal with radio, TV, and so forth. So for all these reasons, equity, reciprocity, and increase in the fair and just compensation for artists, I am proud to spearhead this effort to bring equity to visual artists. I'm glad we're going to be sponsored by Senators Baldwin and Markey, and I'm sure by other members of the House. And I look forward to the discussion. I look forward to a battle over this, but I think we have a pretty good chance of getting this. It may take us a while, but we will get it, I think. Thank you.
First, I want to say thank you for this kind invitation. It is truly a pleasure to be here today. Again, my name is Karyn Claggett, and I am the Associate Register of Copyrights for the U.S. Copyright Office. I want to discuss today the process that the office has undertaken to conduct its review, some of the challenges we faced in the review, and preview some of the interesting things that struck us during the review process that will likely affect our overall recommendation. Unfortunately, as Sharon mentioned, we are still finalizing the report, so I won't be able to wow you with our final report or recommendation due to the shutdown, unfortunately. But I can say, however, that we are very, very close to finishing our review and expect to release the report within the next 2.5 weeks, certainly before the Congress goes out of session for the December recess. So I would say at the latest by December 12th, if not before. In terms of the process for the office's review, as most of you know, we issued an initial report way back in 1992. Representative Nadler then asked us to do an updated review and analysis after he had introduced the EVAA in 2012. And I will say that right now, we didn't really realize how complicated and nuanced the issues surrounding a resale royalty really are when we first agreed to do this review. All of the people, unfortunately, who worked on the 1992 report are no longer at the Copyright Office, so we really didn't have the value of kind of a long institutional memory. But I think we quickly realized that the issues surrounding a resale royalty really are not just about dollars and cents, but also about morality, fairness, and at really some level, emotion. So it was really not an easy review, and we now know why our 1992 report was over 760 pages. We expect our current report to be much less, but it really does reflect kind of the nuanced amount of issues that really confront us as we review. So thank you, Representative Nadler, for the Herculean task that you gave to us in terms of trying to really come together with a specific recommendation in this area. During our review, we did try to basically do a survey on kind of the current thinking, thoughts, and approaches to resale royalty, both here in the United States as well as abroad. In terms of the domestic thinking, we wanted really to update what has happened in terms of the art market and how artists currently exploit their rights under the current legal system. So we issued a Federal Register notice, we requested written public comments, and did public roundtables to really hear from interested parties as to how artists are really operating under the current legal system. And we also generally asked for people to let us know if they had information that they thought would be relevant as we conducted our review. We received over 59 written comments and reviewed the conflicting information really on both sides of the issue. And we also wanted to see, again, how the resale royalty has been approached in the last 20 years since our last report, or 15 years since our last report, in countries outside of the United States. So we were able to benefit in this regard from a number of government or government-sponsored studies, some that have really taken place after those countries have adopted a resale royalty right. Some of the interesting things that I do want to point out that really struck us for our review. One, it does appear that resale royalties or droit de suite is a worldwide trend at this point. At the time of our report in 1992, we had identified only about, I would say, 36 countries that had resale royalties rights. Now, after EU harmonization, of course, in our continued review, we've counted almost 70, so I'll have to double check that, that figure, but about 70 countries that actually now have resale royalties, roughly 13 countries in Latin America, 16 countries in Africa, as well as Australia, the Philippines, and the Russian Federation. We also noted that most of these countries have cited the lack of a viable licensing market as a basis for adopting the right, and really wanted to address the ability for artists to be on par with other authors. And I think from the Copyright Office's perspective, we were too very troubled by the perceived inequity, and really wanted to determine, as we conducted our review, in practical terms, what this means for artists working under the current legal system. In its simplest form, the question for us was, do artists really need more help? We reviewed, another thing we did was review several government studies, and one of the things that I think struck us in terms of the government studies for those governments who've now adopted resale royalties, at least for the most part, the initial studies did not seem to find significant harms to the existing markets. We looked both at the EU study and a United Kingdom study, and noted that in the EU study that was done after the EU directive was announced, that the market share and the works of living artists actually arose in the European Union between 2002 and 2012. That study also noted that countries such as Austria, the Netherlands, and Italy saw their market shares increase after the royalty was adopted. And the study concluded that there was no discernible pattern to suggest that member states which did not levy the royalty on the works of deceased artists have performed better than those that do. And finally, that there was insufficient evidence to indicate that the loss of EU market share for works was directly attributable to the harmonization of the resale royalty right in 2006. So that was a very important study that we looked at closely. We also reviewed the United Kingdom's study of the impact of the resale royalty right on their market. We noted that that study that was commissioned by the UK IPO had noted that there was no evidence that the resale royalty had reduced art prices or diverted businesses away from the UK art market, that the art market in the UK, they concluded, either despite of or because of the introduction of the artist resale royalty, appears to be doing well, and that the UK market has grown as fast, if not faster, than other markets where no resale royalty is available. So those were some really key findings that did, I think, influence our review of this issue. We also noted that there are currently ongoing studies still to really assess how, on the long term, a resale royalty right is affecting the art market. Australia has an ongoing study and review that they expect to issue shortly. The EU, under the directive, has to issue a study every 3 years, and so they will plan on issuing something in 2014. But the studies that we did review were very poignant for some of the conclusions they made or did not make with respect to the effect on the art market. And I know that the auction houses have really strenuously argued that the resale royalty would significantly harm the art market in a number of very, very significant ways, but at least based on some of the data that we were able to review, so far we really weren't really being able to see that in the significant ways that some have feared. At the same time, though, before you conclude that you know what our recommendation is going to be, we did really find it difficult to grasp, how artists are disadvantaged under the current legal system. We recognize that not only artists, but other authors are actually struggling in the current legal environment in terms of being able to make a living with their art or creative rights. And we also struggle with whether a resale royalty is the best way to actually solve this issue. Will a resale royalty right actually serve to put artists on par with authors in terms of being able to make a living in terms of their right? And what are the costs in terms of administration and enforcement? So in that regard, we noted a quote that was in the UK analysis in 2008, where they quoted from a scholar, John Merriman, who wrote about the resale right in 1996. And they noted a quote that said, "In the end, concludes John Merriman, the only plausible explanation as to why well-meaning people who care about art and artists are in support of resale royalty is because they are misguided. Their critical analytical vision is clouded by unfamiliarity with the art world and by a folklore that sentimentally misportrays the artist's life, invidiously caricatures collectors and dealers, does not even mention museums, ignores the art market realities, disregards art world interdependencies, and is blind to the rejection of the right in the great majority of nations and the failure of droit de suite legislation in most of the jurisdictions that have enacted it. So scary stuff in terms of the opposite view of whether a resale royalty right is actually appropriate and is something that will really benefit artists. And all of our review was also covered by generally an information problem that I think that scholars have recognized in terms of assessing the impact of a resale royalty right. That is that there is a significant amount of secrecy in the art market. There's lack of regulation in the art market, so it's really, really difficult to have specific data in terms of how is the resale royalty right affecting the art market, who is actually being able to benefit from the resale royalty right. We've kind of concluded that almost everyone uses one source cited for completely opposite reasons, but it all goes back to one individual. And so that has been kind of a challenge for us in terms of assessing the review. One of the commenters actually in our resale royalty analysis referred to the statistics on the resale royalty right as basically a Rorschach test. Noted that everybody is looking at the statistics and basically seeing what they want to see. So again, thank you for the Herculean efforts that were required to conduct our report. That's partly one of the reasons why it really has not been an easy analysis for us. So I really kind of just went over how we are struggling to really assess this. I want to conclude by kind of generally saying, based on what I just quoted, I don't know that our review will actually make anyone happy, but that's probably the role of government in some sense. We know that we're actually doing the right thing if we don't make anyone happy. I think we are really trying to thoroughly assess all of these issues, looking at the reviews that we've seen, looking at the statistics and data, trying to also assess kind of some of the somewhat amorphous kind of morality and fairness issues that I think are things that Representative Nadler has mentioned and really truly feels as well. But it's a difficult issue. So again, we expect to issue our review no later than December 12th. We'll go over, in terms of our review, basically the lay of the land in terms of how countries are approaching it and the trends that we've seen, and then provide a general recommendation that we hope will help Representative Nadler and the other sponsors as they continue to review this issue. Thank you.
So my name is Theodore Fetter. I'm head of Artists' Rights Society. I'll try not to repeat some of the points which have been made by other panelists, but I do want to address the comment of John Merriman to the effect that any adherent of this bill, of the resale royalty, doesn't know anything about the art market. I've crossed swords with Professor Merriman in the past, and I noticed, incidentally, if I heard correctly, that statement was made in 1996, well before the rule was adopted by the EU in harmonized form. I will echo Congressman Nadler now by pointing out that visual artists are the only vital sector of the creative community in the U.S. who do not receive residual payments for the later sales of their works. Composers and lyricists will collect some $2 billion this year in royalties for their compositions, distributed by their rights societies, chiefly ASCAP and BMI. Playwrights and screenwriters get public performance royalties akin to residuals for later productions of their works. Actors in TV and in film are entitled to residuals. All of these revenues are garnered by creators after their initial creative output. Unfortunately, visual artists receive none of these and do not earn a penny in residual or resale payments. The benefits derived from the resale of their works accrue entirely to collectors, auction houses, and galleries. So a question often posed, and an objection we often hear is, come on, do only wealthy artists benefit from a resale royalty? And the answer to this is a resounding no. The data gathered in the UK, in Germany, and France, where the resale royalty is in effect, show that it is of wide benefit to many working artists in those countries, working artists who are little known. The specific number of individual beneficiaries in the UK, excuse me, for 2012 is 1,302. For Germany in the same year, 1,235 beneficiaries, and in France, 2,201 individual beneficiaries. History abounds with examples of impoverished artists whose works achieved acclaim only late in life or after their death. However, and this is important from our perspective, and I think from the perspective of equity, that the resale royalty might benefit successful artists, it's assuredly no argument for withholding its benefits from all. The need for the royalty does not exclude artists who have experienced a degree of success often late in life, but whose status remains somewhat precarious. A case in point is the artist Rosalind Drexler, who writes, and I'll quote this, I have a hoarse throat, I'm trying to do this, and have some water, and you should forgive me. Rosalind Drexler writes, quote, I have nothing to leave my son, but my work when I die. Much of it has been sold at bargain rates, most of it my best work. Thinking about it, oddly enough, I feel left out of my own story. Why should only the present owner turn a profit, while the artist is left with nothing? I've work to do my art. I won't last forever. I'm 87 years old. But the paintings will go on a lot longer than I will. It's very important for me to be able to know that I've taken care of my son who suffers from disability. This resale royalty thing is not only about money, it is about love and being able to give. It is about legacy. In the end, it is the best kind of generosity. The history of the right, as has been pointed out already, goes back to France. 1920 was followed by Belgium in 21, and later by Germany and Italy, and also, as has been pointed out, the European Union adopted a harmonized rule in 2001, with the UK joining some 5 or 6 years later, accepting the mandate. Very important, and Congressman Nadler mentioned this, the beneficiaries of the resale royalty in countries that have them must be natives of countries that also accord the resale royalty on a reciprocal basis to other countries. The United States does not accord the resale royalty to foreigners. It doesn't even accord it to itself, to its own citizens. Thus, the very significant sale of U.S. works abroad produces no revenue whatsoever for their American creators. Has been intimated, a bill calling for the adoption of the resale royalty was presented in the early 1990s by Senator Edward Kennedy and Congressman Kastenmeier. The result was that formal hearings were held by the Copyright Office at that time. And while its report refrained from recommending the adoption of the resale royalty, it went on to state, this is important, quote, the international community is now focusing on improving artists' rights, including the possibility of harmonization of the droit de suite within the European community. Should the European community harmonize existing droit de suite laws, Congress may want to take another look at the resale royalty, particularly if the community decides to extend the royalty to all member states, unquote. It has been 12 years since the European community adopted a harmonized resale royalty, or droit de suite as it's called in Europe, for all member states, and consideration of American right is long overdue. The California Resale Royalty Act has been mentioned. It appears to have been invalidated by the California District, by the Federal District Court of California, one court, because it purports, quote, in the opinion of the judge, to regulate transactions that take place wholly outside of California, unquote. We believe the court erred in this finding, but it does serve to point up the need for federal law, which would obtain in all the states in which the bill before Congress is designed to achieve. By the way, on June 6th, Judge Michael Fitzgerald, in reviewing a petition of the plaintiffs, held that the court's order is not a binding precedent on other district courts in California. At any rate, the matter is under appeal, as has been mentioned. Artists' Rights Society of our organization has submitted an amicus brief on behalf of the plaintiff. And as I say, the issue could be resolved or obviated if there was a federal resale law throughout the country. Very importantly, and this has been raised and it'll come up again, I'm sure, on the panel, would the U.S. auction market suffer from instituting resale royalty? And what happened to the auction market in the UK when it was adopted in England? Our opponents maintain that the institution of an artist's resale royalty in the U.S. would impair or diminish auction sales in this country. But this was precisely the argument made by the opposition in England prior to the UK's adoption, mainly that it would break the sales market in Britain, that it would wreck it. However, this is completely belied by the subsequent experience of the auction houses in the UK. There, the concern was that after adoption in Britain, the market would flee to the US or elsewhere where there was no royalty. Far from declining, art market sales, as has been indicated, in the UK have increased appreciably since adoption. An article appearing in the Huffington Post, September 25, 2012, bore the title, quote, UK's artist resale royalty law did not damage the art market, despite all the claims, unquote. The article begins, wasn't the sky supposed to fall? And wasn't it supposed to have a corrosive effect on the British art market, unquote. To the contrary, sales have increased to record levels in the UK and exceeds those that occurred prior to the adoption. Moreover, Pilar Ordovas, a longtime head of Christie's Contemporary Art Department and its former deputy chairman of Christie's London, remarked after the institution of the rule in England, quote, the year brought the best sales ever in contemporary art in our history, and as far as paying resale royalties, nobody seems to be concerned, unquote. Anthony Brown, chairman of the British Art Market Federation, who was against the adoption of the rule, admits that the resale royalty law has no visible effect on the British art market. He says, quote, there has been a substantial boom on the contemporary side, and this law isn't going to knock it off its perch, unquote. Indeed, so little does the resale royalty affect the nature of the market that a number of New York-based galleries have opened up ambitious operations in London. These include those of David Zwirner, Gagosian, Pace, and Michael Warner. It's important to note that in London, galleries must pay resale royalty. In the United States, there is no resale royalty for galleries. If paying such a resale royalty is an inhibiting or detrimental factor to the art market, why would these American galleries open up in England? It would make no sense, and they would not venture there. Judge Tully, writing in the Art and Auction magazine, commented about that phenomenon. Quote, essentially what the richer New York galleries are doing is establishing new beachheads in London to find new collectors. In some, the Americans are coming, unquote. They wouldn't go there if there wasn't a right market for them. Lastly, a submission made to the Copyright Office by the attorneys for Christie's and Sotheby's states that the global art market in 2011, the year for which they had data at that point, totaled 46.1 billion euros, or US dollars roughly $59 billion, of which 29% or $17.1 billion occurred from US sales. Needless to say, neither foreign or domestic artists received a penny from these US proceeds, and American artists didn't receive a penny from either the foreign or US proceeds. These proceeds are likely to be even higher this year. Earlier this month in New York, on November 13 Eve alone, Christie sales brought in $691.5 million. Those of Sotheby's the next night are less staggering, short of $80 million. Still its biggest one night ever. According to reports, auction houses typically charge a 25% buyer's commission on the first $100,000 of the purchase, a 20% commission on the next $1.4 million in the case of Christie's, and 20% on the next $1.8 million on the part of Sotheby's. The commission thereafter is 12%. The auction houses also customarily charge sellers' commissions, which can range anywhere from 1 to 10%. The artist, of course, receives none of these fees. Thank you.
So one of the lovely benefits of going last is you learn how much of your presentation other people have talked about, and you get to edit as you go. So I'm going to try and do that tonight so that I don't repeat what others have said. Now I'll start by doing something that I know won't be repeating what they said, and that's introducing myself. I'm Sandra Cobden, General Counsel for Dispute Resolution and Legal Public Affairs at Christie's. While many of you know Christie's, which is one of the premier auction houses in the world, I'll just elaborate on some of what we do. We were founded in 1766 by James Christie's. Today we have 450 sales annually in 80 categories that include fine art, collectibles, wine, jewelry, among others. We have 52 offices in 32 countries and 10 sales rooms around the world. Our primary sales rooms are in London, New York, and Hong Kong. In addition, we have sales sites in Paris, Geneva, Milan, Amsterdam, Dubai, and most recently in Shanghai and Mumbai. As part of being a global player in the art market, Christie's has been engaged in the resale royalty issue for quite some time in 3 different jurisdictions. In the EU, we opposed the EU directive that provided for a resale royalty schedule there. As you know, it passed anyway, and we have been monitoring its impact on the market since. In the US, we have been involved in 2 different ways. We've been involved in the litigation in California over the California Resale Royalty Act that was enacted in 1976. I know Philippa described the statute for you, so I won't. I will just say that 3 entities rather than 2 were sued, one against Christie's, one against Sotheby's, and one against eBay. All 3 of us jointly moved to dismiss the complaints on the grounds that the statute was unconstitutional, and as you heard, the district court agreed and dismissed it on the grounds that it violated the Dormant Commerce Clause. That is currently on appeal before the Ninth Circuit. We are waiting for the final reply brief of the plaintiffs. We expect oral argument sometime early in the new year and a decision to follow thereafter. In addition to the litigation that we have been involved in, we've also been involved in opposing Congressman Nadler's first bill, which, as you heard, expired in the last congressional term without any action. Finally, we have been involved in the discussions in China as to whether or not a resale royalty bill should be enacted there. And we agree, and I can't remember who said it now, that it sounds like, I think Philippa, that that has been postponed for at least the near-term future. Now, Christie's considers itself an advocate for artists. We know that artists heavily rely on the prices gained at auctions to demonstrate the market price for their works, and to show the increase in value of their works over time. Because of our role in supporting a robust art market and in turn necessarily supporting artists, it is uncomfortable for us to find ourselves on the opposite side of an issue with some, but not all, artists. And we do so reluctantly and only after careful consideration of the issues. But we are opposed, and we have many reasons to justify our opposition. Given that I only have 10 minutes to speak to you, I'm only going to tell you about a few of them, primarily 3. The first reason we're opposed is that we think the resale royalty does hurt the art market. Now, you've heard a lot of statistics thrown at you tonight. I'm going to throw a few more. Art Economics, an independent research company, has been researching this issue for a number of years. Claire McAndrews is their primary economist looking at this issue. One of the things that she did was look at the recovery from the recent recession that affected not only the financial markets, but the art markets too. The primary year in which the art markets rebounded from that recession was in 2009 through 2010. What did her statistical analysis show? That the US market rebounded by 120%. During that same time period, the China market rebounded by 121%. And the EU market rebounded by 39%. That's a pretty dramatic difference. In another analysis, she looked at the post-war and modern art sectors, which account for 74% of the fine art market by value, between 2006 and 2012, the sort of key time period for analyzing the impact. During that time period, both the US and the EU lost market share to China, who was developing their art market. However, when Claire McAndrews took China out of the equation and did a direct comparison between the United States and the EU, she showed that the US market share grew by 3% and the EU market share declined by 3%. Now, I agree with others on this panel that say the statistics don't necessarily prove that the resale royalty was the cause for the EU's stagnation. Market shifts likely have multiple causes, but we suspect that one important cause is the resale royalty directive that is in the EU, but not in the US and not in China. And we also suspect that the EU collecting agencies secretly agree. Why? Because when they're arguing in China and when they're arguing down before the Copyright Committee, one of the things they're saying is we need a globalization of the resale royalty scheme. Why? To level the playing field. The second reason why we are opposed to a resale royalty is because it changes copyright law in a manner that dilutes important protections for private property. Now, one of the common arguments you hear in support of a resale royalty is that it is only fair that artists have the same rights as musicians and authors. The problem with that argument is that they do have the same rights as musicians and authors. They have the right to collect royalties for the reproduction of their works. What artists want and what they're asking for here is something that musicians and authors don't have, and that is a resale royalty on their original work of art. So what's wrong with that? I think that's a good question, and I would have two answers. First, it seriously encroaches on private property holders' rights to freely buy and sell his or her property. And indeed, the Copyright Office said in its 1990 to report to this issue, and I am quoting here. The notion of an encumbrance attaching to an object that has been freely purchased is antithetical to our tradition of free alienability of property. That's the first reason. The second reason is once you grant artists that right, how do you distinguish between artists and the many other creators who create some other version of what I will call art? For instance, should the architect who gets get a resale royalty for every subsequent sale of the house that they designed? When I sold my house, that wasn't quite what I was expecting or got. What about jewelry makers who make original types of jewelry? Should they get a resale royalty? Or custom furniture makers? Or fashion designers who create couture wear? All of a sudden, you're left with a significant number of people, all of who will claim that their creations merit the same type of rights that the artists are claiming here. That is generally not how our U.S. property law system has worked. Particularly because we would have no way of easily distinguishing between the artist, the architect, the jeweler, the custom furniture maker, and frankly, if I thought long and hard about it, I could probably come up with another 15 categories. The third reason why we oppose the resale royalty is because we don't think it achieves its goal of helping a significant number of artists. Now, if you have a policy initiative that you think imposes significant risks to the system, you want that initiative to at least be a home run for the goal you're trying to achieve. But again, that's not what the statistics show here. Art economists also looked at how many artists in the EU in 2010 had sales eligible for resale royalty. The answer, 3%. That means that 97% of the artists could not benefit from this directive. And another study, this one by Toby, and I'm going to mispronounce his name, Froschhauser in 2008, shed some light on just who that 3% are. In a study, again, limited to the UK, he showed that the top 10% of the artists collected 80% of the resale royalties collected between 2006 and 2007. In other words, the most successful artists, rather than the struggling artists, are the ones who are collecting most of the resale royalties. So it is our view that a resale royalty scheme is a broken model. But let me make an analogy. We're having a wine reception after this panel discussion and the Q&A. What would happen if Ted, Karyn, and Congressman Nadler were the only ones allowed to have the wine and food, and the rest of us couldn't have any? That's what this scheme is like, and I don't think any of us would think that's particularly fair or, frankly, effective in feeding the rest of us.
Depends on the quality of the wine.
So, for all these reasons and more, we have some serious concerns about the resale royalty scheme. We also have a few concerns that I'm going to mention really quickly about Congressman Nadler's original bill. We're quite interested to see the new one, to see if these issues are still in it, and I understand some of them are. First of all, in his original bill, the resale royalty was imposed only on brick and mortar auction houses of a certain size. So that definitely covered two of us, Christie's and Sotheby's, and possibly one or two more. Now, we are important players in the art market, but we are far from the only players in the art market. So that didn't seem fair to us, that galleries, dealers, e-commerce entities were not covered by this bill. We understood the strategic reasons for doing that, but it didn't seem fair. We also think it's unconstitutional. There was also a point in the bill an omission in the bill that if the art was sold at a loss, that is for less than its purchase price, the seller would still be responsible for paying a resale royalty. Again, that just doesn't seem fair that an artist would get a royalty even when there was no profit in the sale to the collector. And finally, the collection agencies, which often take significant percentages of the resale royalty amount collected, are completely unregulated in this bill. So those were some of the concerns we had with the original bill, and we will wait to see if any of those have been fixed in the new bill. Christie's wants a robust market that supports the sale of art by all artists, both in the primary and resale markets. I've talked now a lot about our concerns about the resale royalty scheme. I think if we're going to talk about our concerns, we should also try and talk about our alternatives. We don't have all the answers, but we do have two suggestions, and we're more than willing to continue the dialogue. First, we think there should be a focus on supporting artists in the primary market rather than the resale market, because that's where 100% of the artists are, not just 3%. Another suggestion we had, and this was a suggestion that was in the original Copyright Office report on this issue, was to amend the tax law to get tax donations, or to allow artists to get tax donations for donating their arts to museums or other public institutions. Those are two areas that we think should be explored further. They're areas that we're willing to engage in a dialogue with other stakeholders in the art market. And we think at the end of the day, they'd provide more support for artists than the current resale royalty scheme being proposed. Thank you.
Well, and this is still just the beginning. We have discussion and Q&A. I think you'll agree with me that, that we chose our speakers well, and that they said very, very important and interesting things. And I have to say, I'm more amazed than anyone that I think we actually made news at this program, which I feared we might not be able to do. I also want to apologize because I had actually intended to introduce each of the subsequent speakers, so forgive me, I didn't, you just sort of passed the mics. I want to start because I know the speakers themselves are going to want some discussion and reaction to a few of what they heard, but I'm going to just want to clarify something that Congressman Nadler said. Did you say, sir, that Congressman Nadler, that in your new bill, it too would affect only the auction houses and not the galleries? I wasn't sure that I heard that.
Yes. The auction, but many more of the auction houses.
But yes, because the level, the threshold is lower. Okay, and in terms of, is it just a draft? So is your intention to wait until the Copyright Office comes out with its report to make it a finished piece? Mm-hmm.
Well, if the Copyright Office comes out with its report by December 12th, I suspect so.
Okay, all right. So those were just two questions. I have a whole list of questions, but I don't want to hog it. This was more to clarify what was said. But Ted Fader, who was clearly chomping at the bit to respond, I guess, to something that Sandy Cobden said. So Ted, go at it.
Thank you, if I may be allowed.
Just not too long, though.
Okay, sure, no. I've noted that Sandy's objection to the fact that galleries are not included, and you feel that this is unfair. So I have a question for Sandy. If galleries would include it, does that mean Christie's would be in favor of the bill?
Well, Ted, I think the obvious answer to that is no, because we have many, many objections, some of what I just listed to the bill. But one objection that we definitely had to Congressman Nadler's original bill is that it focused solely on the auction house to bear the administrative and costs of implementing a resale royalty scheme. That just seems particularly unfair to exclude galleries, to exclude dealers, and to exclude e-commerce entities, particularly because at our auction house, we do auctions, live auctions, private sales, and e-commerce sales.
So, but if it became fair, you still wouldn't accept the rule. I just wanted to make that point.
Well, except it doesn't address all the other things
So
I've
let me-
raised,
Ted,
Ted.
You make it sound really sort of easy to say that if we extended it to galleries, but I don't think that's a really genuine comment on your
Well,
part.
I'm only responding to what was raised.
Okay.
Well, I actually do have a question in response, though, based on what both Ted and Sandy said. I do know that, and one of the things that we noted, of course, is that the EU directive is extended to galleries. I think what Pippa probably was going to say is that it's very, very difficult to administer if it is extended to galleries. So in terms of the experience in the EU, do you have any comments, Sandy, in terms of how difficult administration of the EU requirement to go to galleries and all art market professionals has been? Either one of you, because that is something that we looked at, and so we see both sides. One, that it might be perceived as more fair or to address more artists if it is expanded beyond auction houses on one hand, but we've also noted on the other hand that people have said that it's very difficult to enforce. So experience in terms of the EU model, which does go beyond auction houses, would be helpful for us, I think.
Do you want to take that, Sandy, or should I?
I have a response, but you're welcome to go
No, go
first
ahead,
if
go.
you'd like. So I have two responses to that. I have two responses to that. One, I don't know of any statistical studies that would help illuminate the difficulties of imposing a resale royalty scheme on galleries, dealers that are usually less transparent, well, almost always less transparent than auction houses. I will say, however, that for instance, the IRS doesn't say, I'm not going to tax those small businesses or those people over there because I'm not sure I'll be able to figure out if they're actually complying. That's not the way it works. When you're imposing what is effectively a tax, you generally oppose it on everyone so that everyone bears the burden fairly. Now, I understand, too, the other reason for just limiting this to auction houses. Strategically, if you want to get this bill passed, you want to eliminate as many opponents as possible. And so if you don't expand it to the galleries, if you don't expand it to the dealers, if you don't extend it to eBay, who has a fairly formidable lobbying organization, then you're more likely, or at least that can be the thought, to get it enacted than if you impose it on everybody in the art market. But if you're talking basic fairness dictates that it would be imposed on everybody.
I guess my question really for...
Can you speak
for,
I'm sorry, we have a little mic situation. So.
I guess my question for Ted and for Congressman, Nadler, is if the goal is to benefit artists, and I do understand the theory that any benefit is better than none, but if that's the goal, by imposing it on a section of the market and not the entire market, first of all, don't you run the risk of driving sales from the auctions, especially from places like museums and other charities which use the auctions for the blue sky reasons, for the transparency that is needed when dealing with the public trust. And don't you then run the risk of driving everyone else or a majority of people to the private market where this isn't an issue and this doesn't come up, leaving lower prices and a depressed auction market and hurting the very organizations that you don't want to hurt and which the first bill was aiming to help. And second of all, if you don't do that, and the concern is the logistics, is that a fair way to legislate? Is it a fair way to say, well, we can't go over to those people, we don't have a register of sales, of all sales in America, and so we're going to go with what we can?
Well, that I think is one factor that accounts for focusing on the auction houses, because their sales are more transparent. That's true. Again, I'm not so sure whether you include galleries, whether, once again, you would or would not. It seems that would not satisfy you. I noticed that the statistics that were cited by Sandy were done by Claire McAndrew. If I'm not mistaken, they were gathered for the auction houses. I think she appeared on behalf of the auction houses at the round table in Washington. So I'm not entirely ready to accept those statistics. But in any event, they do show a growth in the major markets. I can only repeat what the deputy director of Christie's herself said in London, that the resale royalty had no effect whatsoever on the market. And the head of the British art market dealers said the same thing. So that belies the notion that somehow the market is going to suffer or be diminished. It's not a factor, and it's not been a factor.
Congressman.
Yes, first of all, let me just comment briefly on the question of the galleries. It is always relevant, two things are always relevant in the legislation. One, ease of administration. Two, effect on ability to pass the bill. I make no apology for either one of them. And if you can help a lot of artists, but not all of them, or zero, I'll take the first situation. Secondly, let me just comment on the statistic, and then I want to comment on a philosophy. We were told that, I don't trust these statistics at all either, because I've seen in Congress statistics totally misused by reports commissioned by partisans, by people who are for or against who are for and against specific legislation. And generally, the more impressive reports come to the people with the biggest pocketbooks to finance the reports. So, for example, and I haven't really looked at these reports, but the resale royalty hurts the art market, and some of the evidence for that is look at the recovery from the recent recession. U.S. and China, the art market rebounded 120%. The EU, the art market rebounded 39%. Very interesting, and probably explained by the fact that the U.S. and China recovered from the recession to a much, much greater extent than the EU, because as opposed to the at first semi-intelligent and then not very intelligent economic policies in the EU and China, the European Union has had disastrous economic policies. And in fact, you can track the economic growth rates of the EU, certainly of the United States. I'll accept China here because I don't know. But the United States versus Europe from 2000 on, and they track exactly mild recovery from the recession of 2001, sharp collapse in 2007 to 2009, and then starting in 2009, mild recovery for both the United States and Europe from the recession, until 2010, when the United States, for the last 3 years, continues a mild recovery, and Europe plummets into another recession because they elected unfortunate governments which impose austerity policies which destroy their economies. So to compare the art recovery, the recovery in the art market, without noting what was going on in the overall economies at the same time is completely wrong. Let me just say one other thing, two other things. We're told that the most successful artists will collect most of the, call them residuals. I don't know what you call them. Well, that's probably true. As with performing artists, obviously Elvis Presley is going to get a lot more residuals, or the Beatles, than someone that no one ever heard of. But the fact that the most successful artists will collect a lot of the money doesn't mean that less successful artists won't collect significant and perhaps to them crucial sums. So that's not an argument against the fairness. And finally, the first thing that was said was that this change in copyright law would dilute private property. It would dilute private property rights. Well, you might say it dilutes it and might not, but I'll take my stand on this with that radical Republican Teddy Roosevelt, who said, and I quote, "Every man holds his property subject to the general right of the community to regulate it to whatever degree the public welfare may require it." And that may be a somewhat more radical view today, but throughout much of American history, that was a very standard view, articulated by people like Abraham Lincoln and Teddy Roosevelt, and certainly others, FDR and so forth. We have the right to regulate private property, to regulate the rights that property conveys. And why is this any more in order to promote the public welfare? And that's what legislative bodies are about. That's what politics is about, different conceptions of what's fair and what the proper role of the state.
Yes, Karyn?
Yeah, and I would actually only add one thing. I think that the 1992 Copyright Office report is cited a lot for that statement in terms of our concern, and I think that we would still share it generally in terms of having a resale royalty right that would in some sense conflict with the traditional notion of free alienability of property. However, at the same time, we did recognize in the 92 report, and I think we would have to recognize now that Congress, as Congressman Nadler mentioned, does have the power to regulate property as it sees fits. It has qualified the first sale doctrine when it has found it to be appropriate, for example, with respect to termination rights and others. So there obviously is, if there's a policy reason for Congress to qualify the first sale doctrine, it has certainly done so in appropriate circumstances. So I hope I'm similarly non-committal as I've been before, but I just recognize that we recognize as well both sides of the coin, that in 92 we did express some concern with this, but we also recognize that, as Congressman Nadler has said, if there are policy reasons for Congress to act in a certain area, specifically with respect to the first sale doctrine, Congress has felt empowered to do so and certainly has the ability to do so as well.
I'm going to let Sandy, because Sandy,
Sure.
and then if Ted, you want to say something, then I want to open it to questions. And then we can come back to the panel.
So there are many things I could respond to here. Being one of the minority on this panel opposing resale royalties, I will point out, with respect to the allegation that the statistics I cited were somehow inaccurate, by saying two things. Again, we acknowledge that there are many factors that play into recovery from a recession, from market shifts, and the resale royalty probably isn't the only one. But I will say one other thing. It used to be that at auctions, it was primarily limited to people within that region. So if you had a European auction, the primary buyers were European. If you had an American auction, the primary buyers were American. Same would hold for China. That's not true today. At our auctions, we have global participants. And by far, often half, if not more, of our participants are not from the region in which the auction is held. So what does that show to me? That somehow something else and not just what was going on in that region, was the cause for the very robust rebounds in the United States, the very robust rebound in China, and the lukewarm 39% rebound in the EU.
If I could just inject something about the statistics, because I'm not sure everyone in the audience knows this, that the situation in England is not as straightforward, because it's only, although England or UK adopted droit de suite in 2006, it didn't affect all the artists at that point. Only living artists were affected initially, and it's only since 2012 that deceased artists are affected. So some of the statistics which were gathered in the earlier round of studies and used for the copyright hearings are not the really final ones, and whether it's Claire McAndrew or anyone else who's doing a further study is going to do a study at the end of this year, which is going to include the impact on deceased artists. And some of them, obviously some of those biggest prices that we've seen in the auction market in New York would not have been affected under the previous regulation, if you will, but would only be affected as of 2012. I don't know how it's going to turn out, but I think for people who don't follow this as closely, I think that's an important distinction. Ted, and then we go to questions. Yes.
There's one thing that's been that's cropped up a few times tonight, and that is calling the Resale Royalty Commission for Artists a tax. I find that somewhat pejorative and objectionable. I don't mind calling it a tax if Christie's is willing to call its 25% buyer's commission a tax, and its 5 to 10% seller's commission a tax. If you're willing to do that, I'm willing to admit that ours might be a tax. It isn't. It's really the same kind of commission, but a much smaller one than that of the auction house exact.
Okay, so we have some, we had 2 roving mics, but one of them seems to be needed on our stage. So at the moment I have, do you have a mic, Katie? Just one. Okay, we'll see if, can you guys manage on this? Okay, then that's good. So do I have any starters for questions? If not, I have a whole bunch that people asked me to ask if there was the opportunity to do it. So let me call on the front here, and then we'll go around. I promise I will call on as many people as I can, so don't feel bad. So let's get to David Nash over there. And if you wouldn't mind, you don't have to, but if you wouldn't mind identifying yourself when you ask your question, because I know some of the questions really stem from a particular aspect of the art world that the various people are from. David.
What impact do you think that the increase in the buyer premium at the beginning of the year, which was about 3 or 4%, what impact do you think that had on market in comparison with what might be a 3% tax or resale royalty? At the beginning, just so that everybody understands, at the beginning of the year, Sotheby's and Christie's increased the threshold of their buyer's premium. That is to say, the point at which they would charge 25% or 20% or 12% was raised. So as effectively, most sellers, most buyers are paying either 25% or 25% and 20%. Am I correct?
Are you correct about what the scheme of our buyer's premium is? I frankly don't have it memorized, so I will acknowledge that we have a buyer's premium, and that we recently increased it, but I will decline, not knowledge, but I just don't have the specifics memorized. I will tell you that our buyer's premium covers a lot of our costs, our real costs in holding auctions, creating marketing material, shipping property here, there, and the other place, and doing everything that is needed to exhibit and sell our auctions. Over time, it's not surprising for you to hear that those costs increase. And as a result, we increased our buyer's premium. I have no idea why. Yeah, and I'm getting to that when I finish my sentence. I don't and can't speak for Sotheby's, but I would say that we hope it has a minimal impact, but it was necessary to reflect our real
point.
costs.
Can I comment here? It may or may not, I don't think the question was asking about the justification for the increase. It may or may not have been justified. It may have been crucially justified. That's not the question. Question was, it was increased. For good reasons or bad, it was increased. What effect did that have on the market? Because the contention that was said a few moments ago was that a resale provision of 3, 4, 5% would depress the market. So if this commission was increased, did that, for good or bad reason, that's not the question, did that depress the market? And if it didn't, why would you say that this would?
I'm sorry, are you asking me?
Yeah.
Oh, okay. Just wanted to be clear. We think that, again, the reasons why we increased our buyer's premium had to do with our own increased costs, and those are passed on to and reflect basically a cost of effectively a cost of living increase. Will it affect the art market? I don't know. We just did it, and no one has looked at its impact yet. We hope it does not, but we did believe that was necessary. We also think that that is different than the resale royalty schemes that apply not just to the auction house's buyer's premium, but to all sales of art in the EU. That appears much more like a blanket, and I'm sorry, Ted, I'm going to call it a tax, than an increase in our commission on putting together an auction.
Okay, the next question, Bert.
Bruce Lehman.
Bruce,
Ms.
yeah,
Colby?
yeah.
I'm sorry?
Is it Colby?
Cobden.
Oh, Compton, I'm sorry.
Yeah.
Ms. Compton.
Or Sandy, are you getting them all? I don't know.
Well, you know, you described your company and Sotheby's as being global companies, and they really are, with offices everywhere doing business all over the world. And so obviously you're operating in some of the world with this system and some of the world not with this system. From your point of view, why should it really make any difference as long as the system is harmonized and every market is the same? Ideally, it seems like that would be the best thing. And then to the extent that prices going up might have a depressing effect on the market, certainly in recent times, prices have pretty much been going up at your galleries or at your auction houses. So that really hasn't depressed the market because the prices are going up. So why really wouldn't you just embrace a harmonization that would have all of your auction houses, all of your markets under a very similar rule?
Because, again, we don't think it leads to a robust art market, and we think a robust art market is part of what helps artists, auction houses, dealers, galleries, the entire market. You know, we seem to be missing the fact that you say prices have been increasing substantially in the art market. They have been for certain artists, but not for all artists. There are a number of artists for whom breaking from the primary market into the resale market is really, really tough and very, very price sensitive. Those people shouldn't be put at a disadvantage because we have created a market that is less robust. We also think that a robust art market and the ability of artists to see their prices increase over time in the auction sales leads them to gain more from their next property. So to say an artist doesn't benefit without a resale royalty is to deny that when his property or her property sells, or her artwork sells really well at auction, the prices of all her new works increase to reflect that new price. Does that make sense to people?
While we're looking for new hands, so if you wouldn't mind raising hands if you have a question, I'm going to ask one that's not to Sandy. Because several people asked me, and I've always been curious about this, if one of the ideas of artist resale royalties is to allow artists to benefit as the market value of their work appreciates and not just have the collector, if you will, benefit, can someone explain to me why the, unless this is no longer the case in the proposed bill, why the percentage will be based on the total amount of the sale and not just on the appreciated amount of the sale? So if a work sold at $1 million the prior time and is now at $2 million, if there is a percentage, why shouldn't it be on the differential between that $1 million and $2 million and not on the total $2 million, so that each time a Picasso is sold, or whoever the artist at effect, and for astronomical prices, it's not on the total amount without a max on top of it. I've been curious, and several people who couldn't attend and asked me to ask questions. That was one of the recurrent questions that they asked. So could someone tackle that? Yeah.
I can just do initially, and I know others on the panel might have something to add as well. I think part of it is administration, that it's a little bit difficult to actually assess and calculate in terms of the sale price exactly. So it's easier to just go on a gross, sale price as opposed to the increased value. I will note that in '92 in our report we recognized that issue, that in some sense if you aren't based on the increased value, that you could be giving a windfall to artists because
To certain artists, yes.
certain artists because when it's a loss they would still be getting a resale royalty. One of the things we had toyed around at that time was perhaps having a presumption. For example, it would be based on the just the gross sale price, and unless there could be proven that there was actually direct evidence that it was a loss, so that it would try to address some of the difficulty in terms of administration, in the sense that as a general matter it would be based on the gross sale, but if there was actually documentation that was easily obtained that the seller could be able to show that it was sold at a loss, then it would be based on the profit as opposed to the overall.
But I have a question about the administration. I mean, presumably the seller, for tax reasons, has to prove to the IRS what he purchased it as so he can pay capital gains tax. So why would it be an administrative issue?
Well, I would say one thing on that, and I think Ted might have others, was just in terms of us being able to have the actual information. So the sales in the art market have routinely been very private in terms of who sold, how much they sold for. I know that in terms of some different countries, they actually do have regulations that require that type of information. But obviously in the U.S., you would confront privacy concerns in terms of forcing the sellers to actually have to identify the purchase price. So those are some of the issues that we just identified in terms of concerns with doing it based on profit as opposed to gross sales.
Okay, I see every hand raised, so let me just call out all of you. Congressman?
Well, I don't know about the administration, and frankly, it doesn't bother me one way or the other. It is not a capital gains tax, and it's not intended to be. A capital gains tax is to recognize gain by the individual. When you purchase something, you don't pay the capital gain. When you sell it, you pay the gain on the differential, how much it increased for you. The person who made the thing that you're, let's assume it's a house or a stock certificate. The builder of the house has nothing to do with the capital gains tax. Well, the fact that it's increased in value. And the company represented by the stock certificate, the company in which you're buying or selling 10,000 shares, has nothing to do with that. Here what we're saying is the value created by the artist should be recognized at any time, whenever there is a transfer. And the fact that it is now worth X dollars and at one point was worth Y dollars, it's not the question of the differential that's relevant.
But
What's,
if-
what's, what's,
But with all due
or the
respect-
loss, I don't care, it's sort of be paid, even if the seller's taking a loss, there's nothing to do with it. It has nothing to do with the gain or loss, by the person who owned it from one date to another date. You're saying that, and just as much as the fact that a songwriter or a performing artist who gets a residual doesn't, his residual is not based on whether the radio is making money or not, radio broadcaster is making money or not. It's based on, it should be based on the value, well, in effect, it's based on the value of the song is measured by how many times it's played. It's a different measurement of value here, obviously, because it's not how many times it's sold.
But in fact, if it wasn't, someone else brought up the capital gains thing, but if the argument is that the artist should be sharing in the appreciated value of his work and not simply the collector sharing in that, then it does argue that it's only the appreciation on which he should.
I think the argument is broader than that. The artist should be sharing in the value of his work, period, as a songwriter shares in the value of his work whenever it's performed. And and he should get that even if it depreciated. I don't know how it could depreciate conceivably, even if it depreciated. I don't think it's a very, and you can agree or disagree with the concept, but it's a very different concept from a capital gain. And a capital gain, again, is paid based on the change in value for the current owner. It has nothing to do with the value in general.
Ted, and then Sandy, and then we go back to the audience.
One important reason for the application on the gross is that's how the international system works. The European Union, it's done on the gross. If you start mixing this up, you're going to have a really rather difficult time dealing with reciprocal ways of assessing what the fees might be. The other thing is that a lot of these works that come up for sale have been in the hands of families for generations. They don't know what the price was, or they might have received the works by a gift of Picasso's or Matisse or what have you. You don't have that information for the most part. And very often, those private sales are not very transparent to begin with. Yet another reason why the auctions are the entities that we've tended to focus on, because their sales are reported or have to be reported under the EU and are reported also here for the most part, whereas private sales often escape such reporting.
Sandy?
Well, so just to respond to one of Ted's comments, if the idea or the concern is, gee, we're not doing it in the same way that the EU is doing it, I'll point out that it doesn't sound like Congressman Nadler's bill is going to do it the same way the EU does it, because the EU covers galleries, dealers, and other sellers, and not just auction houses. So if that is the goal, let's have that be the goal. But more to the point, the California Resale Royalty Act had an exception if there was a loss that was fairly easy to administer, and we administered routinely when a consignor presented proof that in fact they had purchased it for more than they sold it. And so that was a fairly easy way of remedying that inequity to the collector.
I personally am happy to hear that, because the auction houses in California, as has been noted, very often neglected to follow up on the payment of the resale royalty.
So now, back to the audience for questions. So I'm going to take one here, then Hanno over there, and then we'll go to the next one.
Thank you. My name is Bill Sharon, and my question's for the Congressman. If I buy a work of visual art and I don't take very good care of it, and I destroy its aftermarket value, should I have to pay a tax to the government for that? And assuming not, doesn't that indicate that there's just something different about the aftermarket and property rights with regard to for unique property in the aftermarket as opposed to the primary market.
Did you all understand that question? I have to say I had difficulty understanding that
So
question.
if the point of this is to, the congressman had last said that the goal is that the artist should enjoy the value at all times. So, and that's the point of providing this royalty with resale. If I buy a work of art, the artist is successful, his works are doing very well, I just buy it, I think it's mine, I don't take good care of it for whatever reason, and there is no resale market for that work anymore. I've deprived the artist of any right to resell profits.
I think you're correct. Number one, sort of. Number one, you are not the custodian of that artwork. You do not have a duty, except perhaps to art in general, but you certainly have no legal duty to maintain it properly. And you cannot be penalized for not doing so, number one. Number two, government and legislation cannot solve every problem.
Really?
Yes, yes. You have articulated a situation which would be unfortunate to the world of art, unfortunate to the artist who will not get, if you've destroyed it, any percent on the resale value. If I could figure out a way to deal with that without making you a custodian, I might. The legislation does not cure that, but that's not an argument against legislation.
Although I will add that there is some limited cure for that in terms of the Visual Artists' Rights Act, which does forbid certain limited distortions of art.
Okay, so we're going to go back to the audience. Do you have the mic, Hanno? Yes. Okay.
My name is Hanno Ahmad. But what you're saying here is if you don't take into consideration the cost, if I buy something at auction for $1 million today, and tomorrow I sell it for $1 million at auction, and then third day, this buyer sells it, you've got that tax imposed 3 times. And that seems to be going far out of the way of trying to compensate the artist for what's happening. There's been no appreciation, and if you're just selling it on the gross sales price, you're really distorting the concept. But I would have.
No, excuse me. You're distorting the concept if you regard it as a capital gains tax.
You're destroying the concept if what you're trying to do is benefit the artist on his sale, which is in the market, and because it's turned around 3 times at the same amount. To me, at least, that doesn't. But I want to go to the question. Everybody's comparing this to authors and writers and everything. The author gets a copyright when his book is published and when it's sold. The next day, he sells that book. There is no further compensation for him. The compensation is not on transfers forevermore. The compensation is for the first use of a book and of a record or a video or whatever it is. And what we're doing, we're going way out of the way now to tax or not to impose a fine, tax, whatever you want to call it, on transfers forevermore.
Most authors get royalties on their books. It's an advance against royalties, the typical way these things are done.
Yeah, I mean, I would just add to that. I mean, one of the things that, again, we struggle with is looking at the comparison to see whether there was a direct comparison in terms of authors versus artists, who is making more money, who is, advantaged or disadvantaged by the current legal system. I mean, one thing that we, did acknowledge, of course, is that, all rights are the same. As Sandy pointed out, all artists and authors under the Copyright Act do receive the same standard 106 rights. But as a practical matter, what we're looking at it as a practical matter, given how artists and authors exploit their rights differently, are they disadvantaged? So while everyone has the same right, exclusive rights under 106, artists typically make the most money from the first sale. Authors have a lucrative, most likely, reproduction right and licensing right that many artists are not able to take advantage of. So that was one of the things we were struggling with. Really, even though as a baseline and technical matter, artists and authors have the same right, as a practical matter, given the way that they exploit their rights, is there a disadvantage?
I think that we also have to talk a little bit about copyright in this and who owns the copyright, because I think Ted mentioned how theater actor or sitcom actors get residuals. Yeah, they don't own the copyright in the work, so the only exploitation that they get are residuals, which are on a declining scale. So the first rerun of Cheers gets you X, the second gets you a quarter of X, and to the point where you get almost nothing, say 3 cents. But most importantly, they don't have the option of exploiting the copyright in Cheers, as we've learned through court cases. Whereas an artist, unless he transfers the copyright, can exploit the art in other forms other than the original canvas or other media in which the art was created. So I think that that's something to keep in mind. I also think we need to keep in mind that the resale royalty, and I could be misreading this, but I seem to recall that in the original bill, the payment went to the copyright owner and not the artist.
The copyright owner at times is the estate. There are
Right.
numerous situations where the artist is deceased. We've pointed out that very often the artist realizes return, or its family does, after they've passed away. So the heirs of artists may benefit. In that case, they are referred to either as the copyright owners or the successors to the artist.
Okay, so, but it wouldn't be the copyright owners
It wouldn't be a
if
copyright.
the artist was alive. Or if
No,
the artist,
if the
say
artist-
the
They have
artist
given
sells-
away their rights
say the
to-
artist has transferred their
No,
rights.
it's not, it's inalienable. It would not go to somebody to whom the copyright was transferred, assuming that the artist would do that, and the overwhelming majority of artists would not do that. And in Europe, it's almost unheard of.
And I would say across the world, almost exclusively, it's
The
inalienable.
way the bill was written was sort of unclear on that.
And Congressman Nadler, if I can ask, in your proposed new bill, is it still going to be lifetime and then plus 20 years after death in terms of the?
I think it was
70.
It's 70, it's going to be 70. In England, it's 20, if I'm not mistaken.
no,
Is
not
it
in-
70 now as well? I don't mean copyright, I mean the resale.
No, it's coterminous with the copyright
It is,
term.
so it's 70
It's
years.
life
Okay.
plus 70.
Lifetime plus 70.
Lifetime plus 70. I thought it was plus 20. So, questions? Yes, where are my mics? Okay, so, yes, is Victoria? Here. No.
Is that better?
Yes.
My name's Tasha Hutchison, and I come from New Zealand, but I live in America. And
Can you speak a little louder, please?
I came to study visual arts at Yale and got through the master's program there. And I've really, really enjoyed the talk, and I think that each member has said something remarkably valuable. But I must say, we must remember Robert Rauschenberg, who I believe brought this idea to the High Court quite a few years back. And there we have an artist who, in his own lifetime, saw his works go from perhaps several hundred to several $1,000s to several millions of dollars. So I think, unlike a car that can devalue in its usability, artwork tends to, if an artist reaches a certain amount of success, tends to go skyrocket. So we're looking at a market which is perhaps almost way out of control. So essentially, you're allowing, through this new bill, the potential for the artist to get a little bit back for the overall lifetime value of the artwork, and perhaps intelligently put that money back into a Rauschenberg Foundation, feeding a new breed of artists that may well contribute in the future. So.
Well, in fact, I think your very comment shows that certainly Rauschenberg, who may have been the first one at the time of the skull sale, ended up benefiting tremendously as his works appreciated in value, but not all other artists have. Yes? Oh, Dorothy, did you have your hand raised too?
Hi, my name's Richard Lehan from Strophius Art Law. I have a question about the ancillary impacts, secondary impacts of the suggestions. I can see arguments in both directions. You're calling a robust market a positive market. I think that I can identify with that. At the same time, I think there is a need for more regulation. We all know that the art market is, other than drugs, the most unregulated multi-billion-dollar industry in the world, and everyone profits from that in quotation marks, other than often the artists. So my intuition about it is that despite it being perhaps impractical and difficult to implement this in some way, it might, as a secondary effect, bring a need for regulation, which would also help us tremendously with potential provenance issues, because there would be a need to maintain records in a way that would discourage some transactions, but might ultimately raise the profile of the artist in the chain of transactions. So I'm not blind to the economic arguments. As we know, people will always, for $1, get on a plane and travel 5,000 miles to avoid spending that $1. But at the same time, I think that bears also some consideration in the discussion of what we would do in terms of what I think the Congressman is asserting, is that somehow we have to bring the artist back into the picture, also economically. So I was just thinking about those various factors. And
I would actually just kind of echo that. That was something that struck us. Who knew that the art market could be compared to the drug market in terms of secrecy and lack of transparency? So one question that I think that we looked at in terms of our own analysis was outside of the resale royalty. I know that that wasn't really our specific request, but is there a need for greater regulation even outside of the resale royalty market, given the lack of regulation in the art?
That's a whole other IFAR program, I can assure you.
Let me just comment that it's an interesting comparison of the art market to the drug market, and they both are largely unregulated, and both perhaps need some more regulation. And I would say there's a difference, at least I hope there's a difference, I'm sure there is, and that is enforcement in the drug market tends to have a certain finality that we're not familiar with in the art market, and we shouldn't get there.
All right,
So-
I am just going to say, as the defender of the art market, or at least a major art market participant here, that the auction houses, I think, are very transparent in their participation in the art market, and I'm not going to defend everyone in the art market, but I think that you need to look at the different segments of the art market before we go casting aspersions that we all resemble the drug market. We don't.
And I was not suggesting that.
Well,
So do I have some more questions?
Yeah.
Because I know we want to break for some wine, too.
Sorry.
Yes, okay.
My question.
Would you
was
mind
actually-
identifying yourself? if
Oh,
you don't-
Mary Elizabeth Williams. My question was partially answered, but I was wondering what in the bill prevents criminal activity. For example, an artist bidding on their own work at auction to get the royalties profit.
Well, if the artist bids up his own work, and this is an accusation made even at the auction houses, I'm not saying I believe that, but if the artist bids up his own work, he or she runs the risk of buying his own work back. It makes no sense to me. They'll have to pay themselves the resale royalty. I doubt that's what they want.
No, the seller would have to.
Any more questions? I can't see who it is, but let me take that one here, and the pressure is on you because you're the last questioner.
Make it good.
Make it a good one.
Well, I'm not sure I can do that. William O'Reilly is my name. I have a sequence of issues about
one
equitability,
question,
which I'm not
please.
going to raise. But I just wanted to say I just had an extraordinary premonition of coming to an IFAR evening in perhaps 10 or 15 years' time to find another congressman who, surprisingly, is keen to bring forward more legislation, who is pushing for the ADRR, the art dealer's resale right, whereby the penurious heirs of dealers who have spent their time raising the profile of their artists and expanding their range suddenly find they no longer have the benefit of the work that they've done and start demanding extra capital on the basis of that front. That's not perhaps quite a sensible question to ask, but I would ask one sensible question. In the UK, we charge ARR on the buyer, and in
That's
France they
artist
charge
resale rights, yeah.
and in France they charge it to the seller. Which way round would we be doing it here?
Do we know?
I would hope so.
It would be on, as far as I'm concerned, it would be on the seller who receives the fee from the buyer. As a matter of fact, it really affects both buyer and seller.
So is it stated in the bill? I don't remember in the first bill whether that was mentioned.
It was not stated, because I think it has its own internal logic, but I could be wrong, and if we needed to state it, we'll state it.
That would seem to be quite a fundamental element. Who's going to get charged this damn tax?
I would add that's the subject of much dispute in Europe right now. You are correct about the EU. In France, that has been litigated and has resulted in diametrically opposed decisions by the same appellate court 6 months apart. So it's now being considered by the highest court, and we'll have to wait and see what their reaction is.
That's where in Europe?
It's in France.
Court of Cassation.
Well, I think this is a good spot to end. You can approach the speakers over some wine outside. I'm sure we're all ready for it. And why don't you join with me and thank our 5 really terrific speakers.